welcome to the podcast of the IP vertical of the Jindal Digest for Competition and Innovation Laws. Today we have with us Mr. Gaurav Mishra. Mr. Mishra is presently an IP attorney at BananaIP Counsels, where he has been working since 2015 and is primarily involved in developing strategic engagements with IP firms around the world. He completed his LL.B from Karnataka State University and did his post-graduation in IP Law from National Law School of India University, Bangalore. Thank you, sir, for taking out the time to speak to us today. The topic that we will be discussing today is the recent abolishment of the Intellectual Property Appellate Board, that is the IPAB, by the Tribunal's Reforms, Rationalization and Conditions of Service Ordinance 2021.
Laws generally are complex and constantly evolving, which sort of require that technical expertise to adjudicate. And IPAB did, to a certain extent, like you said, mitigate this problem by mandating a technical member to be present during the adjudicating process. So now, without that, do you think how would courts be equipped in dealing with this? Or do, like you mentioned, would having specialized IPR courts be helpful in achieving this?
It's true that the courts have a huge backlog, and based on the stats that are available, it's not hidden that the IPAB actually didn't do much when it comes to reducing the pendency of IP cases before the courts. So matters, if I were to give you an example, you probably think of the authority of IPAB is a lot like the class monitor. If you go back to the class, the elementary school, there was a class monitor and who would say, what, if you talk, I'm going to write your name on the board. There was some fear, but at the end of the day, there was an authority who you preferred over them, which was the class teacher or the subject teacher. So above them was obviously the headmistress or the principal or the vice principal. And you would take the class monitor only so seriously because hey buddy, he's my friend, or she's the one that I share my lunch with. So you would sort of take that into consideration in the kind of power that a teacher or the principal has. You can't expect that from a class monitor. That is probably the same with IPAB as well. So, alright, so now I think if we were to come back on your question whether it increases the workload, and the first thing that we need to probably take a look at is the third and the fourth para of the ordinance bill. Of the reforms bill, not the ordinance, because the ordinance doesn't really state these things. But if you were to read the tribunal reforms bill, actually let me just quickly read that out to you. Yeah. Okay, so para 3 says, in the second phase, analysis of data of the last 3 years has shown that tribunals in several sectors have not necessarily led to faster justice delivery, and they are also at a considerable expense to the exchequer. The Honorable Supreme Court has deprecated the practice of tribunalization of justice and filing of appeals directly from tribunals to the Supreme Court in many of its judgments. So these are actually some very important cases, true, including Sampath Kumar, Chandra Kumar versus Union of India, Roger Matthew, a very recent case, and then you have the Madras Bar Association versus Union of India. So it goes on to say that further streamlining of tribunals is considered necessary, as it would save considerable expense to the exchequer and at the same time lead to speedy delivery of justice. Accordingly, it is proposed to abolish some more tribunals and transfer the jurisdiction exercised by them to the court. Para 4 is something that actually is quite interesting, which says the tribunals that are proposed to be abolished in this phase are of the kind which handle cases in which public at large is not a litigant, or those which neither take away any significant workload from the high courts, which otherwise would have been adjudicated and disposed of speedily. So many cases do not achieve finality at the level of tribunals, true, and are litigated further till High Courts and Supreme Court, especially those with significant implications. Therefore, these tribunals only add another additional layer of litigation. Having separate tribunal requires administrative action in terms of filling up of posts and such other matters, and any such action further delays disposal of cases. Reducing the number of tribunals shall not only be beneficial for the public at large, reduce the burden on public exchequer, but also address the issue of shortage of tribunals and infrastructure. This is something that has actually been pretty much the case with IPAB. As I mentioned to you earlier, vacancies weren't filled up, because of which there was a delay in the disposal of cases. Now, one advantage of moving the cases back to the court, I'm sure you are aware that when the IPAB was set up, it was hearing only the appeals and matters from trademarks, right? And patents and the other IPs were only brought in later in 2007. So the courts are actually, they have historically been hearing patent matters or IPR matters. So it's not new for the courts. Now, as I was mentioning to you, one advantage of moving these to the court is the fact that, at least there will always be a judge who's sitting on rotation to adjudicate on these disputes. You won't ever come across a situation where the High Court is non-functional for years altogether. But like IPAB, because of the lack of appointments, it was not functioning. Then there is also the fact that when you have the rotation of judges on different rosters of the High Court, you are not having to deal with one single judge, who would have some sort of a bias or who could sit and hear your IP matter for years and years on together. Having said that, it's true. The IP cases or IP matters actually require a lot of additional work. You need to require them, you need to monitor them continuously. You need to, get their dispositions high. The expertise, particularly patent matters, and there's a lot of in-depth involvement. True. So when IP cases are merged with the ordinary rosters of commercial cases, there's a good chance that, the courts might diversify their priorities, and the level of urgency that an IP matter may receive in a body like IPAB could reduce significantly. So, of course, and then again, there is this entire aspect of, availability of experts, where cases are scattered all over India. So it might prove to be a little difficult, but assume that even if the court does have an IP bench, it might not be able to call on a lot of specialists who can assess propositions like that or save time and costs. So, yeah, the court actually may or might not. It entirely depends on, how the transfer of these cases are actually given shape to, given an effect to. Because as much as I can tell you, the courts are definitely competent. In fact, the Delhi High Court actually came with the rules in 2020, October, where it was rules on governing patent suits. Very well drafted, in fact. They're talking about infringement claims and how you need to prepare invalidity briefs. They're talking about, and they're not shying away. They say, if there is something that we need an expertise advice on, we would certainly call for a panel of scientific advisors. So there are certainly mechanisms which the court will and can employ to actually come up with some really robust setup for, quick disposal of IP cases. So the courts are definitely competent. We can never, I would never say that the courts are not competent to adjudicate on IP matters, even if they concern patents. Because you must remember, the Novartis case, it actually did start at the tribunal and then ended up with the Supreme Court. And the entire aspect of Section 3D, therapeutic efficacy, all of these were provided by the Supreme Court, not by the tribunals, right? So I think the courts definitely would be able to handle something like this.
Thank you for that, sir. I think that covered everything. Moving on, something related to the administrative law aspect itself. So the IPAB was abolished by way of an ordinance, and the Constitution grants the President the power to promulgate ordinances, and this is considered to be an extraordinary power, which is only supposed to be invoked in case of urgent matters. So, would you say that the abolishment of the IPAB was such an urgent matter?
To be honest, I don't really believe that the abolishment of IPAB was an urgent matter. Necessary, yes. Urgent, no. See, the power to issue ordinances is actually a very special one, and it should be used sparingly as possible. You must definitely not overuse it or abuse it. In fact, the fact that an ordinance was issued for this, and unfortunately, the ordinances have been issued in the past few years more than they have ever been issued in the past. So for me, so the way I see it, for example, I actually get very annoyed with these TV shows. Specifically, you probably will know which ones I'm talking about, where you have the judges who give a standing ovation for every performance, who probably stand on tables and who have these extremely long phrases or some sort of adoration, admiration, whatever you call them. The mere fact that they stand up for every act has sort of diluted the relevance of a standing ovation. I mean, I might obviously be wrong when I say this, but that is essentially how I see it. When you use something excessively, you tend to dilute its value. So by issuing ordinances every now and then, I think we are sort of in some ways diluting the values which are enshrined in the Constitution. There are matters which actually require more urgent attention, which are more necessary. But there have clearly been no ordinance of these, right? So the debate on ordinances actually tends to veer towards the political aspect. So we've been still clear of that discussion. But to answer your question, an ordinance to bring an end to the IPAB was not really necessary, because I think we should have rather waited for about a year's time or until the Parliament convenes next, because if you were to look at the rationalization ordinance, a lot of apart from the customs authority and the other things, I think the rest of it is all pertaining to IPAB. So I don't see the kind of need or the urgency that the government did show in this case, because to be honest, everybody was caught unaware. They tabled the bill in February and the ordinance was issued in April. So there were calls, there was an understanding that this could happen, but an ordinance should not have been the way. You should have probably given that 6 months more time. I don't see how much of a loss that would have actually resulted to the exchequer, because during the final days, the IPAB is actually disposing of some, good number of cases. So, I think they could have actually considered probably giving this time until the Parliament convened next. So, I think ordinance was certainly not the right way for this.
I think that makes a lot of sense. Thank you. And just some concluding thoughts in light of our discussion, keeping in mind the fact that the IPAB did actually have some benefits as well, and what do you suggest is the best course of action that can be taken to achieve a middle ground so that the criticisms are tackled as well as the aim of its establishment is retained at the same time?
So I think we need to make peace with the fact that the IPAB as an institution is unlikely to come back. I mean, I certainly do hope it does, but not in the form it was, prior to the dissolution. So, of course, the IPAB, I see the only way for it to come back is if, by some miracle the ordinance falls and within these 6 months and the legislature then decides to retain the IPAB. So in such a hypothetical scenario where the IPAB still exists, I think there are certain very crucial and critical steps which need to be considered. The first one would be to establish the IPAB as a distinct and different body altogether, not as an extension of the government. It would actually be very critical to ensure that the influence of the executive is completely removed from the IPAB. Point number 2 is the IPAB's stature must be equal to that of a high court. Because as I mentioned to you earlier in that example, right, when you have a class monitor and when you have a class teacher, the way you see them, the way you treat them is very different. So if you were to set up the IPAB in a way that it is similar to the High Court, it would certainly benefit. The third thing, which was a huge problem with the current structure of the IPAB, was it was a circuit bench, right? So it would conduct these hearings across different cities. And again, it did not go through all of these cities. You probably had them mostly in Chennai and Mumbai. So that circuit bench structure of the IPAB should actually be done away with. So you really need to invest a lot of money into setting up these structures. Have a specific body or a specific place where the IPAB functions from. So Delhi has one office, Chennai has an office. So each of these places, and each of these must have a full bench where you're talking about the technical member being present. So as you see, when you consider this sort of a proposal, there are a lot of costs which increase. But yes, if you are serious about these things, then that should be something that should be considered. Then obviously, once you remove the executive, the IPAB should actually be given the liberty to fund itself, fill up the vacancies by itself. So all these issues actually should be addressed. Now, moving on from that hypothetical scenario, if I say, if the IPAB does not come back, which is most likely the case, how do we function with the existing infrastructure or the existing courts? So the first thing that you can do is to establish an IP bench in the High Court. So there have been tax benches in every court, right? And you could probably set up an IP bench in the similar way. You could have all the IP cases, given a different number. You can run them on a separate track. Then, as I was mentioning to you, the Delhi High Court rules of 2020 actually did bring this up. So you could appoint a panel of experts, of scientific advisors for every area. For patents, you could have scientific advisors. For copyrights, you could have experts from the field. GI, plant varieties. Plant varieties also will require some sort of a technical expertise. So they could have them on the board. And the court can actually use their insights to decide on the dispute. Then the third thing is you can have party-appointed experts, or you could have court-appointed experts. So that would actually rule out any bias, because that was not the case with IPAB. Timelines. I think timelines are probably, whether it is IPAB or whether it is the court, you really need to fix some strict timelines, because if you want to have an IP system which is actually which incentivizes the promotion of science and technology, you need to have quick disposal of cases, because these are not exclusive to one another. And the last thing is, if you are talking about establishing specialized IP courts or patent courts, these are something that have already been tried and tested. UK, for example, is one such jurisdiction. China, in fact, went ahead and they have a special standard essential patents court also. And Europe has these courts. So if technical knowledge is a concern when you're talking about patents, you can have specialized IP courts or patent courts. To have them as a separate body or to integrate them with the existing courts is a question of strategy. When I say strategy, it's because there's a lot of factors involved. Because, if you actually put out a patent court separately, you're going back to the same structure. Because IPB was, at the end of the day, a separate body. So again, a lot of these things need to be factored in. You need to have freedom from influence of the executive. So the doctrine of separation of powers must be strictly adhered to, and I think that is probably the only way forward for us. So having the IPAB, not having the IPAB is not really much of the concern. What matters is how we are disposing of the cases and how quickly we are and how efficiently we are working around with these. So I think that with that, I would probably conclude my answer on that.
Yes, sir, I think that makes a lot of sense, and that was a very insightful and informative session. I think that is the end of our question. Thank you so much, sir, for taking out the time to talk to us.